Welcome to Understanding California's New Preemptory Challenge Law, What Trial Attorneys Need to Know. I'm Lori Cripp Martin. I'm a certified family law specialist and the past vice chair for the litigation section. I'm delighted to introduce our speakers today. The first is Martin Ahrens. Martin I. Ahrens has been an employment law trial attorney for more than 18 years. As a trial lawyer, Martin has handled all types of employment-related cases on behalf of people who have suffered a workplace injustice. He specializes in cases involving discrimination, sexual harassment, sexual abuse, retaliation, and whistleblower cases of all kinds, shapes, and sizes. Our second speaker this morning is Justin A. Palmer, who is the founder of Palmer Law Group in Long Beach, California, where he advocates for clients in civil rights, personal injury, and criminal defense matters with a focus on protecting individual rights and securing meaningful justice. Recognized as a super lawyer selectee from 2020 through 2023, Justin combines a results-driven approach with a deep commitment to standing up for those facing some of life's most difficult challenges. And now let's get started with today's presentation.
Wow. Thank you, Lori. That was very humbling. Thank you for that great presentation. I'm really excited to be here. I just got out of a 3-month trial. Justin himself just finished a 1-week, 2-week trial in federal court. And so this couldn't be more timely to talk about California's, the new jury selection law. Justin, did you want to say hello as well?
No, I'm happy to be here. We hope to make it entertaining over your lunch break. And if you have any questions during the presentation, feel free to jot them down and we'll do our best to fold your questions into the presentation.
Yeah, I don't like waiting to the end. So if you've got something that's timely, throw it into the question and we'll try to answer it right then. So let's go ahead. We put together a little slide deck for everyone to try to educate about the new jury selection peremptory challenge law. So we'll go ahead and get that started from the beginning. So just so you know, everything here is in the California Code of Civil Procedure 231.7. So if you want to ask, what's the law? What are we talking about? The answer to all your questions is 231.7. So go ahead and write that down now. CCP 231.7. And if in case there was any confusion, once again, it's CCP 231.7. So let's go ahead and get started. All right. So what we're going to cover here today. First, why the law changed. Talk a little bit of history. We'll do a little Batson Wheeler refresher. Cover the framework. Talk about the presumptively invalid reasons. We're going to talk about, there's no slides on the appellate cases, but we're going to talk about some of the cases so that you can hear all the cases right now are criminal. Because actually when this law was put into place, it was put into place for criminal cases first. And it's only now, as of January 1st of this year, applied to civil cases. And then we'll talk about some practice strategies. Next. Go ahead, Justin.
Say what?
Are you going to lead off on this slide? Or you want me to
I'm sorry. I was hitting the buttons.
No,
so to organize our thoughts about the topic and why we've been asked to talk to you today, we want to frame out what 231.7 was drafted in response to. Traditionally, if you wanted to make, you have your peremptory challenges, of course, but courts are mindful that those peremptory challenges aren't used in a discriminatory manner. And so the two bellwether cases that identified, examined, evaluated whether or not peremptory challenges were used in a discriminatory fashion were the Batson case and the Wheeler cases. Those motions, I can tell you anecdotally, and I'm sure I can point to studies, that those are very seldom, if ever, granted. And really, I think it inversely placed the burden on plaintiffs' lawyers to demonstrate that these challenges were made in a discriminatory fashion. I can remember a case years ago in state court in Palm Springs where we had exhausted our for cause challenges, and then we got to the peremptory stage. And I think this was like maybe my second or third trial. And candidly, I didn't even know about Batson or Wheeler. And so the dude on the other side, all of his peremptories were going for people of color. And the first time I didn't really make a big deal out of it. Oh, okay, fine. We knew you were going to get rid of him, but I didn't know about the framework. And the second one, it's like, wait, what? Then the third one, I'm like, okay, that doesn't seem too right. So I'm sure that if I had exercised my Batson rights at that point, it would have been granted. But I wish that I had attended this session years ago, and I wish I had known about those cases before then.
In fact, there was one of the places where this update came about was there was a Berkeley law death penalty clinic article that came out in 2020 that went back and tried to evaluate the the whether or not these peremptory challenges and Batson and Wheeler was actually having an impact or not. And what they found was that because these Batson Wheeler motions were not being granted, hardly if ever being granted, that the exclusion of minority jurors still persisted over time. So now Batson Wheeler is still a law in federal court. Let's go to the next slide. So let's just for a refresher, if you've got a case in federal court, you know, the whoever's making the motion, whether it's the prosecutor, the criminal defense attorney, the plaintiff side in a civil case, the defense side, if you're saying, hey, the other side is excluding somebody for a peremptory, an invalid peremptory reason, the person making the motion has to first make a prima facie showing that that protected category discrimination was why they're excluding that juror. And then the judge has to rule and say, yes, you've made your prima facie showing, and now, other side, madam, attorney on the other side, what's your race neutral reason? And then the court does makes a determination on that. And so that's still the process in federal court. You still have to sort of convince the judge, and it's really broad discretion. And it's very much like it almost is that, is it more likely true than not true that the race neutral reason is legitimate? And it could be almost any reason given. And the courts have been very freely overruling those Batson Wheeler motions. I had a recent trial where we made two Batson Wheeler motions during the trial, even though the other side kept challenging all of our jurors of color, and not one of our Batson Wheeler motions were given. Just so you know, the materials link is in the chat. So if you look at the chat, I think it's been posted a couple of times. Let's go to the next slide. All right, so weaknesses of Batson Wheeler. It pushes the burden initially on the objecting party. You've got to show that there was that race or some other protected category. That's part of that prima facie showing. Again, we just talked about that those racial neutral explanations can easily be provided. And appellate courts are deferential to trial judges. And then I think that was and there were very few reversals, and that was something that study from Berkeley highlighted. So kind of around this time, let's go to the next slide. So back in the aftermath of all the protests in 2020, and what was going on with the Me Too movement as well, there were changes. Things were going on. There was a change in the Racial Justice Act, even, where now you could go back and look and see if prosecutors or defense lawyers or judges made comments to anamorphize the criminal defendant, that they could even get a new trial. There was all the new laws related to sexual harassment in the workplace. And this was one of the laws that kind of came out from that as well. So we added, once again, CCP section 231.7 to the code. And the goal was to eliminate the unconscious and conscious biases. And that the idea was to prevent discrimination and to encourage and to see a more diverse jury pool. That's the beauty of practicing here in California and here in Los Angeles as well, is that we have, if not the most diverse populaces in the world, I would say. And every jury that I've had, whether we've done downtown Santa Monica or downtown LA, we always wind up getting a broad range of people of color, Asian descent, Latinx descent, Black Americans, people, Muslim Americans, all sorts of different walks of life. It's been really great. Have you had that experience as well, Justin?
Yeah, I have.
So this is an important thing to know. All right, next. All right. So in 2022, it applied to criminal jury trials, and as of 2026, it applies to civil trials. And so all the cases that have come out, and there's about a dozen or so cases that have come out in the last 2, 3 years, are all criminal jury trials. And so I imagine that over the next 2 to 3 years, we'll start to see more cases coming out on the civil side as well. And I believe there's one case right now that's actually pending before the California Supreme Court. We'll get to that a little later. All right. Go ahead, Justin. What are so 231.7 lists out the protected categories. Justin, you want to take us away?
Sure. So, with 231.7 that you're all going to remember after we finish talking to you today, there are protected categories. They include race, they include ethnicity, gender and gender identity, sexual orientation, national origin, and religious, affiliation. And Martin alluded to this before, and I just want to underline it. It's intended to broadly apply to weed out and ferret out any potential challenge to peremptory uses against protected classes and categories.
Yeah. Yeah. Keep going.
Oh yeah. So what I like about the change, one, because it's been operating in the criminal space for the last few years, you have a lead time to figure out what courts are doing, albeit in criminal cases. If you try criminal cases, that might be of interest to you. But first, either party can make that objection. So the plaintiff's lawyers can, the defense court can, the court even can make it on its own motion. And if you read the statute itself, it prescribes specific steps to then evaluate whether or not those challenges are utilized in a discriminatory manner. But beware that you must raise the challenge before the jury is impaneled,
Yeah.
because if you wait later, that might create some issues on appeal.
And I think much like with Batson Wheeler, I think the best practices here is to raise it right in the moment. So
Hmm.
if somebody stands up and says, "We'd like to thank and excuse juror number 9," and you want to use that objection 231.7, I think the best practice is to right then and there stand up and say, "Your Honor, we need to have a sidebar objection 231.7," and then see it happens. And actually, it has to be done outside the presence of the jury. So either in
Hmm.
chambers or at a sidebar. And so you can make that motion later, like if you're seeing a pattern and you get to the end. But again, if you get to the end and you've got 12 people, it all happens so fast, right? And all of a sudden the judge says, "All right, you 12 stand up." And the clerk's like, "Raise your right hand. If you think there was a problem, you got to make that objection right then and there. Be like, 'Your Honor, before we swear the jury in, we need to do something outside the presence 231.7." I think that's the best practice, because one of the remedies is to keep that juror there, or to get and there's other remedies as well that we'll go through and later on here. But that's I think from a strategy standpoint, you got to do it right away. That's what I would say.
And where this differs from the Batson and Wheeler challenges is, in Batson and Wheeler, the jury is still there. So you may be having this conversation at sidebar, depending on who your judicial officer is. And so with 231.7, you stand up and say, "Hey, let's have a conversation." The jury is removed from the courtroom, and then the burden is shifted to the person exercising the cause. And then they have to specifically articulate the reasons why we're getting rid of this particular juror,
So
which
we got
is
to, yeah, go ahead. Sorry.
no, I was going to say it's an interesting dynamic because, hey, we just don't like this person because they're wearing a polo shirt or whatever your reason is, to then now be put on the spot to say, "Well, Your Honor, they ate grits this morning." Like, you have to, it seems a little weird, and the judge can use that information to evaluate whether or not that cause was used in a discriminatory fashion.
Yeah,
But
that's
you were
true.
going to say something there,
Yeah, we got an
Martin.
interesting question about, like, FRCP is silent. Can 231.7 be used in federal court in diversity cases? And I think the answer to that question would be like, probably not, because I feel like jury selection is procedural. And so when you do procedural, I think you could probably try to make an argument in a diversity case that this is a change in substantive law and that the goals here are admirable. I just don't know that that would work in federal
Mhm.
court because, right, where it's procedural, we follow the FRCP, but where it's substantive, we follow California law. And so I think in a diversity case, you could definitely make the argument, and I'd raise it at your final pretrial conference with your federal judge. That's what I would do. You just did a case in federal court, Justin. Did
I
that was
did.
a federal question case, but we
I did, but you know what I'm also thinking too is your ability to do jury selection in federal court largely depends on who your judge is. I was lucky enough to get jury selection and I got 15 minutes to do it. I've had other cases in federal court where the judge is like, I'm doing all the selection and then you're just going to exercise the causes. So yeah, you would be entitled to make the causes, but you won't really have the opportunity to develop the record in the way that you would have if you were asking more expansive questions.
That's true. And many judges in federal court are like, you want to ask a question, write it down, and I'll decide whether or not I'm
Right,
going to ask
right.
your question. So let's go to the next slide. All right. So what's the procedure? Okay. So remember, Batson Wheeler, you make your objection and then you have to make a prima facie case. That's no more. Once you make that objection, who the objecting party, all they have to say is objection 231.7. I think you could probably even to highlight it for a judge, what I might start doing is saying objection Batson Wheeler under the new provisions 231.7, just so the judge has an understanding because they all know what Batson Wheeler is. They might not all know what 231.7 is. And then that step, well, so you just make the objection. Step two, the reason has to, it's outside the presence of the jury. The whoever used the peremptory challenge, they have to give their reason. And then the court evaluates the reason under this new standard. And this is I think the biggest change. The two of the biggest change. The first big change is there's no more prima facie case. You just say your objection. And then the second biggest case is changes this new standard. Let's go to the next slide. All right, go ahead and click through. Okay. So the court has to do their own internal monologue and decide would would someone looking from the outside in as an objective, reasonable person see this? Is it protective standards? And is it more than possible? So it's not just it's like substantial likelihood means is a substantially likelihood that race or protected category. And that means more than a mere possibility, but less than a standard of more likely than not. And so it's kind of in that like 40% range, I would say 40 to 50, right? Because more likely than not is 50 plus one. And so is it more than possible that race or ethnicity or gender, gender identity, something like that, motivated motivated this peremptory challenge, this thing? And I think that's huge because before there was really no standard really given. It was sort of a how the judge felt, but the statute specifically defines substantial likelihood. Um, and so I think that's something that the courts of appeals might even struggle with when we're
Mhm.
looking at and evaluating the trial judge's rulings about whether or not there was a substantial likelihood that the whether or not there was a reason and if the reason given passed muster.
What I like about it too is if I'm looking at my notes, but if you guys want to write this down too, if you look at 231.7 subsection D as in David 3, when you're in this realm about what does substantial likelihood look like, when you're looking from the outside in, would an objective person think that these were used in an improper way? You have factors that you can push the judge towards to really push that point home. For example, is the person part of a perceived cognizable group? Does race, gender, ethnicity in those groups bear on the facts of the case? Did other jurors of the perceived cognizable group give similar answers, but they weren't excused? Was this reason supported by the record? Um, And so, G, has the lawyer or the lawyer's office who exercised the challenge used challenges disproportionately against a given race or gender? That I heard the last one, subsection G, and I automatically teleported back years ago where I was like, yeah, if I had the benefit of this subsection, then my jury would have looked completely different.
Right. And when you think about that's a really good point. So that's 231.7 D3 and it's A through G and it gives, all those 7 different non-exhaustive lists of things that the court could look at. And so, the one that jumped out at me was, did other jurors of other groups give similar answers? Right. And so like, well, they said that they're part of a union or something like that. But the other jurors, you had a male juror say that they're also in a union, but here they are and they're using the peremptory on a woman, and their reason is because that she was in a union or things like that. And I think those are you just got to kind of learn. If you go to the next um, question, right? So these are some of those factors, right? That's that comparative jury analysis. How does that one juror compare to the other juror? Um, did the prosecutor or the defense lawyer or the plaintiff's lawyer, did they not question that juror at all? And all of a sudden they're just challenging them. Disparate questioning, same idea. History of challenge. That's that history of challenges. So maybe some of these things, like Justin was saying at the end of that trial he had all those years ago, he's like, wait a second, as I sit here and I think about it, they challenged all of my Hispanic jurors. Or they
Hmm.
challenged all of my, you might be trying a case and you might have 6 or 7 gay or lesbian jurors on your panel, and all of a sudden they're all gone. So you definitely want to look at that. Um, and so then the go ahead. So now, okay, so the statute gives a list of 13 reasons that are historically linked to discrimination. Go ahead. And so if one of these reasons is given, then they have to rebut it only by showing clear and convincing evidence that that an objectively reasonable person would view the rationale as being unrelated to their race, ethnicity, gender, etc. And so these 13 things are presumed invalid. So if somebody stands up and says, well, the juror said that she has a distrust of law enforcement, then then the prosecutor, let's say, or the defense counsel has to get up and show by clear and convincing evidence um, that the reason given are unrelated to their race or their ethnicity. And the judge has to bear in mind unconscious bias. The judge has to think about that unconscious bias and think about whether or not that if that juror's answer is if one of these 13 reasons is given as one of the reasons. And so that goes back when we talked about that the objection is made and then the reason has to be given immediately. You might want to print this one page out from the materials and put it in your binder. And this is under 231.7E as an echo. Because if the other side, if you make your new Batson Wheeler motion 231.7 and they give one of these reasons, then you can point out to the judge and say, look, hey, Your Honor, this is a presumptively invalid reason. They have to show by clear and convincing evidence now that it's not due to their race. We're going to walk through these in a little more detail. All right. So, distrust of law enforcement, belief in racial profiling, relationship with someone arrested, juror's neighborhood, or receiving state benefits. So, unfortunately, these are things that have been historically associated with minorities and people of color. And this is what the evidence has bore out from our history of of racism in this country and discrimination in this country. And so somebody who's had more experience with law enforcement and negative experience with law enforcement, just because they say they have a distrust of law enforcement, that's presumptively invalid. Right? Belief that they believe that cops racially profile. That's presumptively invalid. That, when we look at the mass incarceration of people in this state and in this country, the likelihood of a person of color, somebody who's been arrested, is just greater than somebody like me. Where they live, there are just higher instances. So, Justin, one of the questions we got, what does belief in racial profiling mean? Well, how would you answer that? Like if you
Well, I likened it, or I connected it to the first bullet point about distrust in law enforcement. So, in foster, I handle a bunch of civil rights cases. And so, in the very rare and limited opportunities I have to do my own voir dire, one of the questions I asked the jury to get a vibe check about what are your thoughts about law enforcement in either direction. And sometimes jurors explain to me that they feel communities of color are profiled. They feel like that's not okay. That is what I believe, or that's what I'm interpreting in terms of the belief in racial profiling. Do
yeah,
do you think that? I'm sorry. Go ahead.
and the statute says like a juror expressing a belief that law enforcement officers engage in racial profiling. That's that's what that specifically means. But I mean, you might actually get jurors that just come out and say that, right, Justin?
Hmm. Hmm. Yes. The short answer is
Yeah.
yes. And you want
So
to know that, and one of the things I learned, because I didn't have any lawyers in my family. I didn't come up in a firm. You're learning this on the fly too. So you want to time these questions so that they're not poisoning in state court all 60 or 70 jurors that you're getting, or all 24 that you're getting in federal court too.
yeah.
And then you're leaning in and being curious. But that's separate from the actual peremptory discussion.
Yeah, and part of that question that was asked by one of our attendees was, is it that the potential juror believes that one party or the other engages in racial profiling, and the potential juror believes this is okay? I think it wouldn't matter if the juror thinks it's okay or not okay. If they just
Hmm.
believe in racial profiling, the statute doesn't say if they think it's a good thing or a bad thing. They just say, hey,
Hmm.
do they believe that law enforcement officers engage in that? Um, for me, if that was the reason that the other side gave, I'd be like, that's a presumptively invalid reason, which kind of leads to like the next question that we got. And I think that this is good. Like clear and convincing evidence will overcome the presumption. So what's an example? You would need to give detail more than, I think, if you're trying to justify your objection, you'd have to explain that and give more information about other indicia about
Hmm.
what happened. They were evasive in answering questions.
Right.
Um, their demeanor, they had a tough time. Other types of, you know, their other things about what they said. I think you need to get more of that. So if you're giving an answer in, back at that beginning, right, the reasons required immediately, I think strategy wise, your best bet is to list out 10 different reasons. Because if one of those reasons is one of these invalid reasons, but you've got 9 other legitimate reasons, I think you would have a better argument to say, look, it's not because they're fill in the blank. It's because of these other, yeah, that might be a presumptively invalid reason, but it's not the only reason. So,
That's the pro hack too. Like I'm guilty of it. We all we receive information completely differently. So if you say 10 words, I may catch 6 or 7. You have to be dialed in when you're asking these folks these questions and practice active listening. Because the statute, I think, specifically addresses that. If you're unable to articulate why you want to get this person off, and then you resort to these examples. Well, they don't like law enforcement. Okay, and like it doesn't matter if they can they be fair and impartial? If you're just repeating or parroting things that you think are going to torpedo your case, that's not going to fly. So really lean in when they're asking these questions to determine whether or not A, you want to keep them, but also to survive this type of challenge under the new structure.
Most definitely. And one of the questions we got from somebody else was like, why not show social or sociological studies that show that racism is institutional racism is embedded? I think in the fly of the moment at trial, you're not going to have that there. I think the argument you could make to the judge is be like, look, Your Honor, these things are here because those studies exist
Mhm.
already. We know
Mhm.
these things to be true. And so um, I think you probably even have a better argument to substantiate your objection if they list out two or three of these things as their reasons, like
Mhm.
when they're listing out all their reasons, if they go. So go to the next slide, actually. It's got more of the presumptively invalid reasons, the last ones. Um, Not a native English speaker, speaks another language, how they dress or appear, their employment field, unemployment. And and it's not just their employment field. It talks about employment in a field that is disproportionately occupied by members in that protected category, or that serves a population disproportionately comprised of members of that group. So if you're serving, uh, maybe if you worked as a probation officer, or if you're
Mhm.
working, um, uh, in some other field that you could say like, hey, look, Your Honor, like the reason they just gave is because of their job as an X. And people that work as an X, we know from common sense, disproportionately support that fill in the blank community. And so that's that employment field. That's what that's talking about. It's not just what do they do. It's do they work in a field that you've seen supports that that group. I mean, it could be you could be like, hey, they work at a church. Well, and if your emotion is because they're getting rid of all the people that are very faith-based because of their religion, then that would be an invalid reason, right? If you and so that would be the type of thing.
And on that study too, I think it's a good point. I might read the study and then fashion a series of topics or questions to examine the entire veneer about them, because you get the entire group talking about these things, and you can use those also as additional data points to either make these challenges or to resist the peremptory challenges later
Yeah.
in in a creative way.
So one of the cases that came out. So this is where I wanted to add. So there was a case called People versus you're at Swiggy, and I'm sure I'm pronouncing it wrong. It's 101 Calap 5th 271. In that case, a Hispanic juror, the reason that there was a preemptory challenge made, and the prosecutor said, "Oh, it was lack of her life experience," and the court said that wasn't enough to overcome the invalid reason because her lack of employment or underemployment. It was a presumptively invalid reason. And so the prosecutor just gave lack of experience and unemployment or underemployment here is one of the lack of employment or underemployment, unemployment, right? Under 231.7 E11 says lack of employment or underemployment. And so when the prosecutor's like, oh, her lack of experience in the work field, that was not enough to overcome that clear and convincing standard. There was another case, People versus Ortiz, 96, Calap 5th, 768. And the prosecutor said that this juror wasn't able to answer or understand some very basic questions. And the trial court made its own observations. And then defense counsel was like, hey, those are invalid reasons. And then the trial court then went to the prosecutor and they sort of worked together. And the prosecutor said, well, we don't know if that person is being truthful or if he might be hiding some kind of bias. That's what the court asked the prosecutor, and the prosecutor said yes, and that this juror hasn't been able to answer questions in a certain way, and so they don't understand the questions, they don't answer the form of the questions, and so that evasive answering and that evasive questioning done, um, the court found was sufficient. And so it was sort of that more of an explanation that was given by the prosecutor that overcame that presumptively invalid reason. So let's see if I saw some more questions come in. So yes, of course. In other words, it's not just come up with a different reason. You're really supposed to come up with the reason in the first place. There were some other demeanor-based reasons, right? If they're inattentive, or there's a secondary list, like there's like kind of a catch-all. If they give these answers and stuff like that, that you can use to support your objection. If these demeanor-based reasons are given, you could say that it's because of one of these. You have to kind of tie it back in if you're the one making the objection to the presumptively invalid reasons. Right. So again, this is the new standard. Court asks whether an objectively reasonable person would see the protected status as a factor. That's something less than substantial likelihood factor. And then is it more than possible? Less likely than not. And then again, I wanted to highlight that new procedure. All right, so yeah, so this is a really good point. So CCP 2031, this is a question. Does not expressly state that applies to potential jurors with disability. But then the statute says, this is from a person named Richard Prager. This is great. Thank you so much for sharing this. CCP section 231.7 does not expressly state that it applies to potential jurors with disabilities. Yet, CCP section 237.5 reads that a party shall not use a peremptory challenge to remove a prospective juror because of a characteristic listed in Government Code section 11135, which includes disability as a class. And so does 231.7 apply to potential jurors with disabilities? I would argue to the court that it does, because I think the purpose of this is it was supposed to be read and interpreted broadly. And I think you just did the legislative and legal analysis in your question. And I would argue yes, that would be an improper basis to exclude people and persons with disabilities. The hard part about that, I think, from a strategy management, you don't always know if someone's got a disability unless they come out and tell you. So we're talking about sidebars, right? Hey, I wanted to share with you that I have this fill in the blank. It could be many disabilities now are not visually obvious. And so I think that might be the hard part, where you might not know that information. And something, whether or not it's a disability, it could just be somebody has a broken body part, or they're walking just with a limp, and it couldn't be necessarily a disability. What do you think, Justin?
I had a case where we had selected a juror, and I was really like stoked about her. Like, she had great energy. Her reasons were great. She was laughing at all our jokes. And so she sat, and then she starts to cry a little bit. And I'm like, uh-oh, that's not good. And then she passes a note to the clerk, and then there was a whole sidebar situation, and she expressed that she had a disability. And we were trying to figure out on the fly what to do there. And to Martin's point, yeah, I think in a room full of strangers, you don't want to bear that much vulnerability and to share that particular detail. But we were able to excuse her and to thank her not only for her bravery and mentioning that to the group, and also to fashion a different juror to get back and to do the work. But yeah, I agree. I think 231.7 would include that discrimination as a protected class.
And somebody responded in the Q&A, where an objection to the use of a peremptory asserts a protected group covered in 231.5 but not 231.7. She's saying, though, there was a case that came out, People versus Hernandez. I missed that one. That should be litigated as though the objection fails under Batson Wheeler. So maybe this is an area where we need to write our our legislators and
Hmm.
expand to be included with that. There was another question. If a juror is wearing a button that says challenge authority, is that clear and convincing? I mean, I think I'd want to know what they mean by that. I would ask them, be
Hmm.
like, can you tell me a little bit about that button? What does that mean? That's how I would approach that. And very likely would then it only has to be that clear and convincing. Remember, it's if it's in one of those presumptively invalid.
Protected, yeah. Hmm.
Let's click through. We've talked a lot about this, defending a peremptory challenge. State your reasons clearly. Link, go back. Link explanation to impartiality. Avoid generalized statements and dreamt the invalidity directly. You really need to. If someone made an objection that I was excusing jurors and made this one of his objections, I think you just need to be as detailed as possible. And that's where, when you do your jury selection, you're writing all your notes, or if you've got co-counsel with you writing notes about their answers to their questions. If you've done a good probing voir dire, you should have lots of reasons of why that juror just makes you feel uncomfortable and it's just not the right fit for this case. All right. So what happens if the objection is sustained? So if that juror is still there, you could actually keep that juror in the box. That's one of the remedies. If there were if you make it later on and let's say there were 2 or 3 people of color or women or something that you thought was the reason for the improper, you could ask the judge to give you, hey, Your Honor, I think they improperly used these 2 or these 3 peremptories. I should be given additional peremptory challenges. If it's bad enough, you could quash the entire veneer. And you could even declare a mistrial. And those options are in the statute. That those things are what could happen. So like if for the mistrial, I think would really happen if the jury was impaneled and then there was the objection, and you're not supposed to do it that way, but I think the legislature saw that that's just a reality that could happen. And so and of course, under 231.7, this is subdivision H, if the judge and counsel can get creative, they could come up with other reasons as well. Next slide. So, right, just do it, right? Do a good voir dire.
Next slide.
Create a clear record. Don't use stereotypes. And I think that's really important. I think the more cases I've tried, the more I've realized that it's really important to listen to jurors.
Mhm.
When I've sat in on trials and the other side gets up and it's just the lawyer speaking, I'm like, they're not learning anything. But, right, Justin?
Yeah, it's not intuitive because some people, I won't use generalization. Some people like to they listen to respond rather than listening to engage and vibe out. And it took a while. I don't think I'm perfect at it, but the goal of this whole thing is where are you from and how do you think? Not to challenge those thoughts, not to challenge those beliefs, because you're not, And the example I use is just leftovers. I think fresh fruit. Well, Martin's a cook. I don't know if you guys knew that or not. He's like a Michelin chef.
That's this guy.
Uh,
That's Justin.
and show them your garden, dude. Anyway, I think fresh fruit is superior to anything in the world. So every night I make a fresh plate. I don't. I People have leftovers, and that's totally fine. I think those people are wrong, but I'm not going to change their mind about leftovers, right? You tell me your reasons why you like them, and we'll agree to disagree. I take that same mind frame when I'm interviewing prospective jurors. I'm not going to change you that reheating food in glass jars makes sense. And I don't want to. But tell me that if there's a case about a microwave, this isn't the case for you. You know what I'm saying? Like, use that approach to learn, to being curious, and to listen with an open mind to better help your client.
Yeah, I think from a trial perspective, that's the best way, right? So it's like when, and I've had people say like really mean things to me in jury selection, like about the cases that I've got and attorneys and things like that. And I just say, like, to me, that's gold. That's a gift. Thank you for sharing that. For me, doesn't sound like you're the best fit for this case. I like to use mini openings. And I think if you can get and if you ask for a mini opening, it's required to give it to you. Use the mini openings. Talk about your case. Have the defense talk about their case. And then with that little nugget of information, jurors are going to start to tell you what they think about your case or about the defense case or the prosecutor's case. And when you get that kind of more specific, as opposed to just like, this is a personal injury automobile case, or this is a med mal case, or this is a breach of contract case, or this is a, a fill in the blank kind of case, when you can give them a little more meat on that bone, they'll start sharing things with you. Go to the next slide, actually, Justin. I think this kind of hits on it, right? You can ask them those clarifying questions. You can tie the concerns to the facts of your case. And you can get that information, which will help you, frankly, make more educated peremptory challenges across the board. Forget about
Mhm.
the Batson Wheelers and the 231.7. You're just going to do a better job finding better jurors for your case. Yeah, someone put it in the Q&A. We need to learn to listen and listen to learn, right?
Mhm.
And just, I mean, just listen and say thank you. Thank you for sharing.
And knowing when to stop too. Like if the juror gives you a bad fact and you know it's bad, don't double tap on it. Thank you very much for your courage and really telling me that. I appreciate that. Miss Jones, do you mind if I ask you some questions?
There you
Just
go.
keep it pushing.
Go to the next slide, maybe. We're kind of making good time. So make your objection, raise it immediately. Let's just move on to the next one. We've already covered that stuff. Prepare your questions, track the responses, right? Link your challenges, your peremptory. If you stand up and you have a peremptory challenge in your heart, in your mind, and in your heart, you should know the why. Build your record. What's next? Key takeaways, right? Definitely changes it, lowers the threshold. You have to adopt and adapt to a good voir dire strategy and build your record. And so um, the next slide gives a summary, right? Just like
Mhm.
A versus B, because you still are going to have to use Batson Wheeler for certain things, I guess, for the disability ones right now until that gets remedied. Thank you so much, whoever put that in the Q&A. Sydney, thank you for doing that. That was great. Little nugget right there. Um, and then, follow, read them. So in the materials, it's just an article that I wrote last summer comparing these. And then there's been new case laws that have come out even since then. And there is currently a case before the California Supreme Court, which was whether or not you can, and then go to questions and discussion. So how will this, things for you to think about, right? What concerns do you have? How will this change it? And then that was it. I wanted to talk. Go ahead and hit stop share, Justin. And what I wanted to point out that California Supreme Court case is People versus San Miguel. So keep your eye out for that. And the question was whether or not the trial court overruled defendant's 231.7 objection to the prosecutor's challenge. And at the lower court, the Court of Appeal held that the lack of attention by that prospective juror overcame the presumption of invalidity based on the prosecutor's use of their peremptory challenge. The prosecutor actually asked that person whether or not, only one question, whether he would require the victim to testify to reach a decision. And that juror was of Latino descent and was the only Latino man left of the 18 in the box. and the prosecutor, so responses to why they got rid of them were extremely brief, and it sort of went back and forth, and the trial court found that that was enough and overcame the 231.7. So that's an interesting case that's coming up. So those are kind of, those are my, anybody have any other questions they want to throw in the chat or in the Q&A? But one thing that, and if not, I had one other thing that I want to address. Justin, do you have any other thoughts?
Nothing other than to express my gratitude for you spending a few minutes on a Monday hearing me and Martin talk. This was great. I'm glad that I was able to meet you all virtually, and I hope that you guys stay in touch. We dropped our emails in the presentation, but feel free to reach out if you have any questions. You want to talk shop, you want to hang out, grab a drink, whatever.
Yeah, most definitely. Thank you for allowing us to share a little bit of information and knowledge on something that's new and kind of interesting, you know? So get out there and try more cases.
Yeah.
I think that's it. So, so we've got 9 more minutes. I wanted to fill up. If we had a little bit of time, I wanted to share. So a friend of mine started trial today, and he said, Martin, been a while since I tried a case. What's the process for cause challenges and peremptories? And what I realized is there's this dance that that people forget about, right? So you got your 12 in the box. And in I'll talk about civil cases. If it's a challenge for cause, the defense goes first. And then it goes to the plaintiffs. But when you get to the preemptories, if you lose a juror, you usually have those 6 down here, and that's where the comes in. And so one thing that I've noticed is that what do you do if you get down to that final 12 and you're thinking about challenging juror number 9, but there's nobody down here? And the law's unclear. And I just wanted to throw that out there because I think, you're allowed to question jurors to intelligently exercise your peremptories. And if you don't know what's coming, and I've had about 50-50 success with judges on this, saying, look, I don't know what's coming. I can't intelligently use my peremptory. Let's fill those 6 and talk to those 6. Some judges allow that. Some judges are like, no, you got to have an empty seat in the box. So I just think it's an interesting fact. I think it benefits both sides of the aisle to know what's coming, whether you're the next ding up. So that was just something I wanted to thought about. Oh, the name of the question. The name of the case pending is People versus San Miguel. And the court of it was 105 Calop 5th 880 was the lower court, but People versus San Miguel before the Supreme Court is 327 Cal Reporter 3D 897. So that's it. Any other those are my thoughts.